What are the contemporary trends in administrative law? Administrative law has evolved significantly with the changing role of the state. During the 19th century, governments performed limited functions such as maintaining law and order and collecting revenue. However, with the emergence of the welfare state, the responsibilities of the government expanded to include education, healthcare, social security, environmental protection, consumer welfare, and economic regulation. As a result, administrative law has become a dynamic branch of public law that regulates administrative authorities while promoting transparency, accountability, efficiency, and good governance. Contemporary trends in administrative law reflect the continuous adaptation of legal principles to meet the demands of modern governance. Meaning of contemporary trends. The term contemporary trends refers to the recent developments and changing approaches in administrative law that aim to make public administration more efficient, transparent, accountable, and citizen oriented. Modern administrative law is no longer confined to controlling administrative authorities. It also focuses on improving governance, protecting human rights, promoting digital administration, encouraging public participation, and ensuring speedy delivery of public services. These developments enable the administration to respond effectively to the changing needs of society. Evolution of modern administrative law. Administrative law has developed alongside the changing functions of the state. During the era of the police state, governmental activities were limited and there was little need for elaborate administrative regulation. The Industrial Revolution increased the responsibility of the government in regulating industries, labor, public health, transportation, and economic activities. After the Second World War, the concept of the welfare state transformed the role of government. Administrative authorities were entrusted with wider responsibilities relating to social welfare, economic planning, environmental protection, and public services. Consequently, administrative law expanded rapidly and developed important principles such as natural justice, judicial review, delegated legislation, administrative tribunals, legitimate expectation, and proportionality. Today, administrative law continues to evolve in response to technological advancement, globalization, and increased public expectations. Administrative law in the welfare state. The welfare state aims to improve the social and economic well being of its citizens by providing essential public services and ensuring social justice. Administrative authorities are responsible for implementing welfare schemes relating to education, healthcare, employment, housing, social security, and environmental protection. Administrative law provides the legal framework within which these authorities perform their functions. It regulates administrative discretion, ensures fairness in decision making, protects citizens against arbitrary action, and promotes responsible governance. Thus, administrative law enables the welfare state to function effectively while safeguarding individual rights. Challenges before modern administration. Modern administration faces several complex challenges. Rapid technological development has created new areas requiring regulation, such as artificial intelligence, cybersecurity, digital governance, and data protection. Increasing public expectations demand greater transparency, accountability, and efficiency in governmental functioning. Administrative authorities also face challenges such as bureaucratic delays, corruption, misuse of discretionary powers, inadequate coordination among departments, and environmental concerns. Globalization has further increased the need to harmonize domestic administrative practices with international standards. These challenges require administrative law to evolve continuously in order to ensure effective and responsive governance. Need for administrative reforms. Administrative reforms are necessary to improve the quality of governance and strengthen public confidence in government institutions. Modern reforms seek to simplify administrative procedures, reduce delays, eliminate corruption, enhance transparency, and improve the delivery of public services. The introduction of e-governance, the Right to Information Act 2005, citizen charters, online grievance, redressal systems, digital public services, and anti-corruption institutions such as the Lokpal are important examples of administrative reforms. These measures promote efficiency, accountability, and citizen participation, making public administration more responsive to the needs of society. Legal provisions. The contemporary development of administrative law is supported by various constitutional and statutory provisions, including Article 14, equality before law and protection against arbitrary state action. Article 21, protection of life and personal liberty through fair, just, and reasonable procedure. Article 32, constitutional remedies before the Supreme Court. Articles 226 and 227, writ jurisdiction and judicial review by high courts. Right to Information Act 2005 promotes transparency and accountability. Lokpal and Lokayuks Act 2013 establishes anti-corruption institutions for public accountability. Conclusion. Contemporary administrative law has evolved from merely regulating administrative authorities to promoting transparent, accountable, and citizen centric governance. Modern developments such as good governance, e governance, the right to information, administrative justice, and administrative reforms have transformed public administration into a more efficient and responsive system. As society continues to evolve, administrative law will remain a dynamic branch of public law, ensuring that governmental powers are exercised fairly, lawfully, and in the public interest.